Hi, everyone. Welcome to another episode of the Ask Amity Show. Today, we'd like to talk to you about a pour-over will. So what is a pour-over will? A pour-over will is a special type of last will and testament used in conjunction with a trust-based estate plan, which creates the living trust as the only beneficiary. And it really can save the day when the grantor of a trust, the person who created it, neglects to transfer all their property into the trust over the years and has no other will to determine which beneficiaries should receive that omitted property. So how does a pour-over will work? So instead of governing the distribution of all your property, a pour-over will state that any assets that have not been funded into your revocable living trust should go there when you die. So effectively, it names your trust as a beneficiary of any property that does not already belong or fund into your trust. So that property does not pass directly to a living beneficiary through some other means, such as a designation of a beneficiary through your life insurance policy or retirement account. So in effect, this pour-over will basically states that, if you did not name a beneficiary on that asset, or if you did not fund that asset or transfer that asset into the name of your living trust, then this pour-over will state that the living trust, in effect, is the beneficiary, so that it flows through to your living trust to that beneficiary that you directed in the living trust.
So one of the beauties of having a living trust is that it is meant to avoid probate of the property which have been transferred to the trust. Unfortunately, any of your property that isn't funded into your trust before you pass will require some sort of court involvement, whether that be probate or some other type of petition, even if it's directed to your trust via a pour-over will. So your property will pass to your heirs according to state law if you neglect to fund it into your trust. But again, if you create a pour-over will, then it will pour it into your trust, just like what Jen said earlier, but it will require an extra step, some kind of court petition. So not a full-on probate process, but some kind of court petition, whether that be a hexa petition or some other type of spousal petition, all of which we can discuss with you more in depth if this is a situation that you find yourself in, where there is a property that wasn't funded into the trust, but there does exist a pour-over will. Again, if there's no trust, no pour-over will, then you're gonna find yourself in probate court most likely. And when you're in probate court, you're gonna have to follow the California rules of intestate succession, which means that by default, the state has a list of priorities of beneficiaries that will receive your loved one's property when they pass. If you want to hear more about this and want to talk to us, call us. We offer a free 20-minute consultation. So give us a ring and we'll be more than happy to discuss this and other probate matters with you. Please like this video and subscribe to our channel, and we'll see you in the next video. Thank you.